As part of international criminal justice, earlier we discussed the notion of international criminal justice and individual criminal responsibility broadly at a conceptual level. What constitutes international criminal justice and individual criminal responsibility? We had seen that the international criminal justice is based on the understanding that the perpetrators of large scale crimes and grave crimes at the international level should not go scot free, and there should be a fight against impunities. So, with this idea, the framework of international criminal justice has evolved as part of international law. So, international criminal justice generally was seen as an exception in relation to the crimes of piracy as part of universal justice, as part of a universal jurisdiction in the past. So, now it has become an important framework to deal with large scale crimes which takes place at the international level, which means either between states or at the time of the conflicts between a state and a non-state actor. Even sometimes when there is no conflict also, these large scale crimes do take place. Now, we discuss how the idea of international criminal justice and individual criminal responsibility evolved in relation to institutional growth at the international level. For the first time, the idea of international criminal justice was taken up by states at the end of the First World War. After the end of the First World War, there was an attempt to prosecute those individuals who are accused of committing certain crimes at the time of armed conflict, that is in the form of war crimes and other grave crimes, but it could not materialize the way it was thought. So, therefore, there was an unsuccessful attempt was made at the end of the First World War to deal with these gross crimes at the international level in relation to the conflict. So, after the First World War till the end of the Second World War, there was no other major attempt to deal with international crimes in accordance with international law and international institutions. When the Second World War was coming to an end, the Allied forces have decided to prosecute those who are accused of committing the large scale crimes from the Axis powers, that is essentially from Germany as well as from Japan. So, as the war was coming to an end, the international community was coming to know that the large scale violation of individual rights belonging to certain communities, primarily Jews, was taking place within Germany as well as outside Germany in occupied territories occupied by Germany. So, there was a lot of discussion in relation to what is to be done at the end of the Second World War. So, there was finally a conclusion that was arrived at, which decided the Allied forces have decided that to establish an international criminal tribunal to deal with these individual crimes. So, therefore, a charter was adopted which established the Nuremberg Tribunal, the International Criminal Military Tribunal at Nuremberg. The purpose of establishing the Nuremberg Tribunal was to prosecute German war criminals. So, the tribunal was established through a charter, and the tribunal prosecuted several individuals and punished them for crimes, specifically for the crime of war crimes, crimes against humanity and crimes against peace. At that time, there was no idea of the crime of genocide under international law. So, therefore, the idea of crime of genocide was not dealt with by the Nuremberg Tribunal at the end of the Second World War. So, there was only 3 crimes which were dealt with by the Nuremberg Tribunal. On a similar lines, another tribunal which was known under the International Criminal Tribunal for the Far East, or otherwise known as Tokyo Tribunal, was established for the purpose of prosecuting German war criminals. On the lines of the Nuremberg Tribunal, the Tokyo Tribunal also had jurisdiction over war crimes, crimes against humanity and the crime of aggression, that is crime against peace, and at the end of the prosecution they were successful in prosecuting and punishing some of the individuals for the perpetration of certain crimes. So, both the tribunals have dealt with individuals not as part of the state or a state structure, but as independent individuals for the purpose of establishing individual criminal responsibility. So, in a way, these two tribunals can be considered as a first major experiment under international law, where the criminal jurisdiction was exercised by the international institution in accordance with international law in a major way for the first time under international law. So, at the end of these two tribunals, there was a discussion, there is a discussion on what is the historical role these two tribunals have played. There is a major accusation that these two tribunals have rendered essentially a victor's justice. The reason why it is called as victor's justice is that because individuals accused of committing certain these gross crimes belonged only to the defeated states. Even though there were accusations that those who won the war, that is the states from allied states, individuals from allied states are also accused of committing certain crimes, but they were not prosecuted by these two tribunals. Therefore, it is generally referred to as victor's justice. So, one of the dissenting opinions rendered in the Tokyo Tribunal was by Indian judge Justice Radha Vinod Pal. He emphasized on the biased nature of the justice that was being rendered by the Tokyo Tribunal. So, therefore, there is a general understanding that these two tribunals are generally accused of rendering victor justice, but on the other plane, when we come to the development of international criminal law and the individual criminal responsibility, they are generally referred to as establishing an important precedent as part of international law with regard to individual criminal responsibility. So, therefore, there is a historical relevance in terms of understanding the various developments as part of international law. So, therefore, despite the fact that both are accused or are generally criticized for being rendering victor's justice, they play a significant or continue to play a significant role in the understanding of individual criminal responsibility and international criminal justice. After the Second World War and after the experiment of the Nuremberg and Tokyo tribunals, there was not much of a progress with regard to the individual criminal responsibility at the international level, and that continued to be till early 1990s. Now, the reasons for not much of developments in relation to individual criminal responsibility during those roughly 3 decades can be attributed for various factors. It could be attributed for the Cold War situation, or it could be attributed for the kind of international political scenario that existed at that time. But from 1990s onwards, again there is a revival in certain respects of the idea of individual criminal responsibility. It started with two important developments. These two important developments are basically two important conflicts that have taken place in early 1990s. One is in relation to former Yugoslavia, other one in relation to Rwanda. So, in these two conflict situations, there was a large scale accusations of large scale violations of international human rights and international humanitarian law took place. So, therefore, there was an argument that the perpetrators of these crimes need to be prosecuted and punished. So, therefore, the United Nations Security Council came up with establishing two ad hoc tribunals, one for the former Yugoslavia situation and another for Rwanda. So, therefore, ICTY, the International Criminal Tribunal for the former Yugoslavia, was established for the purpose of prosecuting and punishing individuals who were accused of committing these crimes in the context of former Yugoslavia. That was in 1993. In 1994, a similar tribunal was established by the United Nations Security Council to deal with accusations of crimes in relation to Rwanda, which is referred to as International Criminal Tribunal for Rwanda. So, these both two tribunals have developed immense jurisprudence by way of rendering justice in the form of international criminal justice, by way of punishing individuals who are accused of committing war crimes, crimes against humanity, genocide and the grave grave breaches regime of the 4 Geneva Conventions of 1949. So, when these two tribunals were established, there was a momentum was gathering towards having a permanent international criminal court rather than continuing with ad hoc tribunals. So, these two tribunals, ICTY and ICTR, were ad hoc in nature, but there was an argument to establish a permanent international criminal court. As a result of the international community, which started work as part of the United Nations framework from 1945 onwards, culminated in the adoption of the Rome Statute in 1998. The Rome Statute basically establishes a permanent international criminal court. So, therefore, all these tribunals which were established in the case of Rwanda, in the case of former Yugoslavia, as well as several other hybrid tribunals in the context of Cambodia, Sierra Leone, the International Criminal Court is different from all of them. It is different in the sense that it is a permanent court with a permanent institutional structure as well as a statute establishing this court. So, it is a kind of a general treaty making process that led to the adoption of the Rome Statute, which established the International Criminal Court. The statute was adopted in 1998 and came into force in 2002. So, since 2002, this permanent international criminal court is undertaking investigations in several conflict situations. But almost all the conflict situations, or at least majority of the conflict situations which it has undertaken in terms of investigation and prosecution, are in the context of Africa or in African continent. So, therefore, it is now there is a serious criticism being levelled against the functioning of the International Criminal Court, for the reason that the majority of the cases before this court as of now are from a particular context, that is African continent. So, therefore, it is argued that the International Criminal Court is essentially functioning against the weaker states and not going into the prosecution of those individuals belonging to powerful states, even though there are several accusations and allegations against those individuals belonging to the powerful countries. So, it is a challenge for the idea of international criminal justice and the International Criminal Court to deal with a situation where it has to prove that it works impartially, objectively, without taking into consideration and socio-political situation of the individuals and the states from which they come. But so far the court has not succeeded in countering this criticism of acting only against the weaker individuals coming from weaker states, because so far the court has not taken up any serious investigation in relation to the accusations of crimes being committed by individuals belonging to powerful states. It is expected that the success of the idea of international criminal justice through a permanent international criminal court can be understood as an important development as part of international law, provided it renders criminal justice to all without being influenced by the economic, political and military strength of the states from which the accused individuals come. With this video, we end the week discussion on global justice and international law. Thank you.